Officer Day, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Hello?
Yes.
What is your name? What is your name?
Tracy Lucas.
I'm sorry?
Tracy Lucas.
Tracy Lucas? I have the other
Yes.
side. Let's get started. Where'd he go?
Yes.
We are on the calling file number 191735859, credit acceptance versus Tracy Lucas, date and time for objection to garnishment. Your appearances.
Judge, may it please the court, my name is Attorney Richard Gruson. My bar number is 35222. Judge, I am the attorney of record for the plaintiff, and I am also the my partner, Lynn Libby, is the attorney of record, and but I'm the respondent to defendant's objection to a wage garnishment.
I'm sorry, go ahead, Mr. Rusin.
Yes, it's a tax garnishment, my mistake. So
Tell us your name, ma'am.
Tracy Lucas.
You are the moving party, ma'am. What is the basis of your objection to garnishment?
For one, I respectfully request to be provided proof of this alleged item specified in the contract.
Do you have any other basis for your objection to garnishment?
Yes, because the amounts are not correct. I have 3 different accounts, payments from them. So I need them to provide me the bearing of my signature.
Well, ma'am, do you have any other basis for your objection to garnishment?
Other than that, the total of it is not correct.
What is incorrect, ma'am?
The amount is 3 different amounts. So I need them to provide a signature.
All right, Mr. Rusin, your response.
I was trying to make some sense of it, Judge. I can tell you that I've kept a manual balance and electronic balance of all payments received. I see that as of this moment, that by means of garnishment after judgment, I've received $3,180.66. I will also tell the court that there is, a balance remaining statutorily today of $11,068.49. That is due in part for two legal reasons. Number one, every time there is a filing fee and a service fee, then that's called taxable costs, and that gets added to the judgment balance, which I'm keeping a record of manually and electronically. And also, right on the judgment, it says that the judgment was going to accrue statutory legal interest at 13% per annum, and that's because the car note that was defaulted upon by Ms. Lucas and forming the basis of the lawsuit on the car note had an interest of 22.99%, but by law is capped at 13, which is reflected on the judgment. So I ask that the court deny the objection to income tax garnishment at this time.
Is there anything else, ma'am, you want to say?
I would like to be proven with my signature how much, because it's three different payments. It's one for $6,941. It's one also for $11,513. And also on the paper, it says $10,783.66. So at this time, I'm just confused of how much I owe. I do owe. I know that I surrendered the car, but it's three different payments. I understand what he just said. I don't have a problem with paying. I just need to be on a payment plan, but I need to be proven how much in writing with my signature, how much do I owe?
All right. Court's prepared to rule in this matter. First of all, ma'am, the Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment as a method of challenging the validity of the underlying judgment. So we're long past the point, ma'am, of being proven what the amount is by seeing your signature. That ship has sailed. That was resolved by the judgment. In regard to your objection to garnishment, the court finds you have failed to state a valid objection to garnishment. You have a unfortunate financial situation in the sense that the judgment against you is accruing interest at the amount of 13% per annum. Put another way, the judgment that was entered here in September 2019, almost 3 years ago, has now almost 36% interest, 39% interest accrued on.
Okay, so that's what that is, interest?
Yes, ma'am. It's 13% per year, ma'am. And every time you file a pleading that requires a response, a motion of fee, a garnishment fee, things like that, those costs are added as well. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. The last matter.
So I can't get on the payment plan?
Ma'am, I was
No,
going
I'm asking, can I get on the payment plan?
Perhaps you could let me talk, and perhaps we could reach that point.
Okay.
Thank you. The last matter before the court was your request for installment payments. You were asking the court to pay $50 every 2 weeks or $100 per month. Mr. Russo, what's your position in that regard?
Judge,
I have a written response from you.
Excuse me, Judge. I will stipulate to that, and in so stipulating, I will close my argument by suggesting on the record that defendant may want to consider, after this hearing closes, calling my office, my phone number. Let's see if she has my phone number. My phone number, if she has a pen, is area code 586.
Oh,
Wait a minute.
Mr. Russo,
586.
Excuse me, are we talking in person now? Or are we talking on the internet?
Oh, my office number is on public records.
Oh, okay, go ahead.
And she's not calling my cell phone. But it's also in the State Bar Journal. So my office phone number is 586-868-2737. Again, 586-868-2737. Call my office. You can settle the whole case. But today I will stipulate to that order that she's asking for $50 every 2 weeks.
All right. Court will enter 3 orders. There'll be 2 orders denying the objection to garnishment. There'll be an order granting a motion for installment payments by stipulation. We'll send them on out today. Thank you both for coming in. We are off the record.
Thank you, Judge.
Wait a minute, can I ask the question? Can I ask the question? Because I don't understand.
Ma'am?
Oh, my God. Yes, I don't understand. Like, so is they going to stop the garnishment?
The wage garnishment will be stopped. The
Okay.
installment payment order only protects wages, does not protect income tax, refunds, bank accounts, lottery winnings, credit union accounts, things of that nature.
Okay.
All right. Thank you.
Thank you,
You're
Judge.
welcome.
We're off the record.
All right.
Mr. Begg. Good morning.
Good morning, Judge.
What case do you have today?
I've got Midland versus Rhea Jackson.
Okay, I think I have Rhea Jackson. Let's get started. She went away. That didn't work out too well. Let's see if she comes back. Good morning, ma'am. What is your name?
Jackson.
All right, let's call your case.
I'm sorry.
Let's call your case. This is file number 17126-271. Midland Funding versus Rhea Jackson. Date and time for objection to garnishment. Your appearances.
J. Latif Beg, BAIG, P36820, appearing on behalf of the plaintiff and the attorney of record.
And your name, ma'am?
Rhea Jackson.
You are the moving party, ma'am. What is the basis of your objection to garnishment?
I would like to
Stop the garnishment and
make monthly payments.
Do you have any other basis for your objection to garnishment?
Other bases besides
income wise is the reason.
reason why I want to do the monthly payment.
Well, ma'am, you didn't file a motion for installment payments. You filed an objection to garnishment.
I
And that's
did
why
both.
we're here.
I did both, sir.
Rhea Jackson?
Yes, sir. Yes, Your Honor.
Well, the problem we have on the installment payments is that the 14 days hasn't gone yet, so it's not in front of me. So I should probably see that sometime later this week. Do you have any other basis for your objection to garnishment?
No,
Mr.
I filed both the papers at the same time, so you wouldn't have both. Is that what you're stating?
No, what I'm saying, ma'am, is that you have to elapse 14 days before the motion for installment payments can be considered. And the other objection to garnishment is supposed to be heard within 10 days. So you can see there's different time periods. Mr.
Okay.
Begg, your response to objection to garnishment. Mr. Begg, your response.
She hasn't complied with the court rules as far as proper objection to garnishment, Judge.
Okay. The objection to garnishment will be denied. You have an absolute right, ma'am, to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. As I indicated to you, your motion for installment payments should be coming forward for consideration in the next 3 or 4 days before the court. Thank you for coming in. You're off the record.
Thank you.
All right. Who we got?
Judge.
Hello. You have Carmen Diaz versus credit acceptance.
Yes.
Okay, I had her a minute ago. Where'd she go? Let's try admitting her again. All right, we are on the record. This is 15104-778. Credit acceptance versus Carmen Diaz. Date and time for objection to garnishment. Your appearance.
Judge, may it please the court, my name is Attorney Richard Rusin, my bar number 35222. I'm the attorney of record for the plaintiff, and today, I'm sorry, my associate partner, Lynn Olivier, was the attorney of record. I am the respondent to defendant's objection to a wage garnishment.
Ma'am, what is your name?
Carmen Diaz.
You are the moving party. What is the basis of your objection to garnishment?
The amount is not correct, and I just need to enter into a payment arrangement with them for an amount that I can afford. I only work at Amazon, and since they've been garnishing, I haven't been getting much money. So I'm supposed to start back work tomorrow, and I just need to get into something reasonable. But the amount is not correct. The car was I only had it for 3 months. It was stolen, and the insurance contacted them, and they were given the asset back. And then they were also paid an amount from the insurance to fix the vehicle, whatever the criminals had done to it. But we had already moved on to another car, so they kept it. And I never heard anything from it. So I would understand like if there's like a gap in like what the amount is versus the loan. But I definitely shouldn't own for over the entire loan plus all this interest. Like, I mean, there's no credit. Like if I'm paying for the whole thing, give me the car back. Like they have the asset. And I had actually got another loan from them for a whole nother car and paid that car off. Like we had moved on, and I hadn't heard about this judgment. And then now I'm back working, and yeah, so the amount definitely needs to be adjusted, but I also would like a reasonable payment. I know they asked for 300. I can't afford that.
Mr. Rusin, your response to the objection to garnishment.
Yes, Judge, I can tell you that judgment was entered in this matter on May 27th of 2015. And the amount of the judgment at that time was $15,471.03. Since May 27th of 2015, I have received as payment on the judgment by means of garnishment, the total sum of $9,705.09. Now, right on the judgment, it indicated that the judgment interest statutorily was at 13% per annum because the defaulted car note that was the underlying basis of the complaint was in the amount of $24,009. I'm sorry, my mistake. The interest rate was 24.99%. So I can tell you that the amount claimed by me at this time of $20,258.87 is just by doing owing based on statutory interest and costs and bringing this case up to the present moment. Now, if defendant wants to make an installment payment petition, I can tell her that based on the $20,000 balance I've just cited into the record with the 13% interest, the interest is accruing at the rate of $219 per month. I don't know what defendant wants to pay, but in order to have her break even to pay this judgment off in whole eventually, she would have to consider an installment payment of in excess of $220 per month.
All right. Anything else you want to say, ma'am, in regard to the objection to garnishment?
He didn't say anything about the asset. Like, why was that not deducted?
Ma'am, Michigan Court Rule 3.101K provides you may not use the objection to garnishment to challenge the validity of the underlying judgment. That ship has sailed. That's
I
not.
thought I filed two. I should have two motions on file. So
Yes,
that
you have an objection to garnishment, which is what I'm deciding now, and you have a request for installment payments. What I'm saying to you is that in regard to your objection to garnishment, the court rule prohibits you from doing what you were attempting to do, which is
What do I
saying,
need to file?
excuse me, ma'am, don't interrupt me again.
Oh, I apologize, sir.
You may not use the objection to garnishment, ma'am, as a means of challenging the validity of the underlying judgment. That ship has sailed. Your objection to garnishment will be denied. You have an absolute right, ma'am, to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Now, in regard to your request for installment payments, where he has filed a written objection, the problem that I have with your request of, where's I had it right here, $50 a month. Ma'am, that's not paying interest on the judgment.
Could it just be a temporary until I get back on my feet? Like, sir, they are taking so much of my check. And I was actually on disability when he started the garnishment. And so they were taking my disability payments from Amazon. And so like, I don't have enough money to survive. Like just with the obligations I have for my life, I need to make at least $1,600 a month. I barely make a little over $2,000 a month with Amazon before the garnishment. And then once they started garnishing, you know, and I understand this is just me. I was irresponsible in my 20s. I'm trying to do better right now, but I cannot afford, like if I could just, even if they could agree to $50 a month for 6 months, just to show like that, hey, I am willing to take care of my responsibility. It's just that I got to find a better job. Like I'm trying.
The problem that I have is that you're asking me to sign you up for indentured servitude.
Okay.
If you pay $50 a month on this judgment, 10,000 years from now, the judgment will still not be paid. Because like a credit card, you are accruing interest every month on the judgment. At 13%, a $20,000 judgment is $220 a month. So until you start above 220, you're not going into the principal at all. All you're doing is paying interest. Do you understand that?
Yeah, but could you just do it for like 6 months and then I could start once I get a better job? I need 2 jobs in order to pay these bills. So I have the job at Amazon and that's like overnights, but like I gotta get a main gig. I was working at like a summer program and it ended like last week. And so now I'm trying to find, like I do nanny work, like I dog walk, like I need to get on my feet. I'm not saying like $50 forever, but you know, I wanted to make a payment of good faith. It's just that where am I going to get this 220? I mean, I'm on food stamps, sir. I'm literally on welfare.
Well, the problem that I have is they are entitled by law to 25% of the earnings you have. If you were willing to pay the interest rate on, that would be one thing. It's getting worse. It's not getting better. Your situation is not improving, and I'm not helping you by allowing you to continue to pay money on interest that's not even keeping up with the current interest payment. I'm going to deny your request for
So
installment.
the minimum you'll allow is the 220?
Something plus 220. 220 is just keeping you even, man. Do you understand that?
240? I mean, I literally can't afford it. I don't know what I'm going to do. I just need to get them out of my paycheck so I can actually survive.
I think that if I can interject this time, I think that in perfecting the record, I think that Ms. Lockhart needs to call my office, talk to my staff.
I have. They won't talk to me.
Okay.
I called your office and they wouldn't talk. That's why we're here.
Ma'am, I can't finish the thought if you don't let me finish the sentence.
I apologize.
So you need to call my office and ask about settling the case instead of arguing with my staff about why we're garnishing you. So if you call my office, say, I'd like to see if I can settle this case, maybe that might be viable. On that, I'll leave it to you. I rest by asking that the objection to wage garnishment be denied, the installment payment be denied, and defendant is warmly invited to call my office to try to settle the case and specifically use the S word of settlement.
Ms. Carmen?
I did not call and argue with anyone. I tried to talk to them and they said because a garnishment was in place, they couldn't make any payment arrangements with me.
All right, what he's saying is that if you want to talk about settling the case, you should use the word settlement. The court is going to.
Can I have the exact phone number and the person I'm supposed to speak to, please?
Well, you can call my office, and my office number is listed on my website homepage. I'm also in the State Bar Journal. My phone number for my office is area code 586-868-2737.
2737. And who is the person to speak to about settlement?
And my staff people. Yes, ma'am.
Ask for a settlement coordinator.
That would be a good idea.
All right, the court's going to deny the objection to garnishment for the reasons stated. Likewise, I'm going to deny the request for installment payments. Again, you have an absolute right to appeal my decisions. You have 21 days to file your appeals in the Wayne County Circuit Court. We're off the record.
Thank you, Judge.
Hello,
Hello,
what is your name?
Fisher Williams.
I'm sorry?
Fisher, Kisha. My last name is Williams, Williams.
All right. Let me see. It's 42417. Okay, let me put you back in the waiting room. I don't think your other side is here yet. Waiting room. Bradley Johnson. Mr. Johnson,
Morning, Your Honor.
what do you have?
Security credit against Bryant
Okay, let me
for
see.
10 o'clock.
Let me see if this is Bryant here. Hello? Hello? Hello?
Hello,
What is your name?
Amber Bryant.
We are on the record calling 21170-059. Security Credit Service versus Amber Bryant. Date and time for objection to garnishment. Your appearances.
Morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And tell me your name, ma'am.
Amber Bryant.
You are the moving party. What is the basis of your objection to garnishment?
I don't recall the debt, and I never received any type of communication whatsoever about this. The only communication I received was from my job stating that they were garnishing me. I've never received anything or reached out, did something in the court or been garnished before.
Do you have any other basis for your objection to garnishment?
Other than the fact that another objection is right now with being garnished, I have 3 children and we're homeless right now. I've been going to different homeless shelters. We've been staying at different hotels. So it's like impossible for me to afford to give somebody $250 a week because we barely surviving as it is.
Your response.
Your Honor, most of her objection is an attack on the underlying judgment, which isn't allowed under MCR 3.101K1. Her being served the garnishment by her employer is exactly how that process is laid out in the court rules. So we'd ask that the objection be denied.
All right, court's prepared to rule in this matter. Ma'am, is there anything else you want to say?
I wasn't saying that the about just the garnishment. I was stating that I did not receive any communication, period. No court dates, no nothing.
All right. The court's prepared to rule in this matter. I note for the record that you were served by alternate service, certified mail return receipt, posting on the door by a 36th District Court officer, first class mail, at the very address that you use in your petition today. Michigan Court Rule 3.101K specifically provides, ma'am, you cannot use the objection to garnishment to attack the validity of the underlying judgment. Financial hardship is something we understand as a reality, but is not a valid basis for an objection to garnishment on a legal basis. Having failed to state a valid objection to garnishment, the court must deny your objections. You, of course, have an absolute right to appeal my decision. That appeal must be perfected. In 21 days today, the Wayne County Circuit Court will send out to both of you orders in this regard. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Hello?
Hello,
All right, I have, Keisha Williams. I have an opponent here, but he apparently is not coming in as of yet. Let me see if I can get him in here, but he has not.
Good morning.
There he is. What is your name, sir? What is your name? Unmute yourself.
Yeah, because I can't hear.
I can't hear him either.
I still can't hear him.
No, I think he left me. I think he's coming back. If not, we'll proceed without him.
Okay.
I give him a couple of seconds. If he doesn't get back, we're gonna move forward. I've tried letting him in early twice and he didn't respond, so. Here he is. Let's see if he's gonna come in. All right, he seems to be connected to audio now.
Okay.
We are on the record calling file number 20161393, Modern Financial Services versus Keisha Williams. Date and time for objection to garnishment, your appearances. Tell me your name, ma'am.
Tisha R. Williams.
Sir, your appearance.
Your Honor, can you hear me?
Now I can. Your appearance.
My speaker is not working. I'm going to have to sign back on. I'm sorry.
I can hear you now. Proceed.
You can hear me, but I can't hear you. I'll sign off and sign on again. I'm sorry, Your Honor.
This is the third time I've tried to get you in here, counsel. I'll give it another try, but I'm going to have to move forward.
Mm.
All right, he should be signing back in shortly, ma'am.
Okay.
Here he is. Let's get him in here. All right, let's get started. We are
Okay,
on the,
hello.
I'm sorry, I hear you, I see him. Mr. Naslin, can you hear me? I don't have any audio from you, sir. We need 45 minutes for this. All right, ma'am.
Yes.
I can't get his audio working. We aren't seem to be going anywhere. So I'm going to adjourn this for 1 week. And we'll give him an opportunity to get himself together. So I'm going to adjourn this from today, the 17th of August, to August 24th.
Your Honor, I think I got a court date already that day too for another garnishment.
Is it a video court today or
It's video, all of them video. I got like
Okay.
every Wednesday, I got court, I got visual, video court.
Is it here in the 36th District Court?
Yes, it is.
Hang on, let me see. This is maybe him. Hello?
Hello, this is Eric Nasland, the attorney that I can see you, but I can't hear you, and apparently you can't hear me.
Let's call your case, counsel.
Pardon me?
Let's call the
Oh,
case.
thank you.
This is
Thank you.
20161-393, Modern Financial Services versus Keisha Williams, date and time for objection to garnishment. Mr. Naslin, your appearance.
Thank you, Your Honor. Good morning. Eric Nasland, P42648, on behalf of the plaintiff.
And what is your name, ma'am?
Mr. Williams.
Ms. Williams, you're the moving party. What is the basis of your objection to garnishment?
The car is old, and for me to pay $10,000 for an old car that they sold at the auction for like $1,200, and the value of the car is not even worth $10,000 is absurd. And they garnishing my wages at my main job for this car, and I just can't afford for them to take the garnishments out of my check. And I have 4 other garnishments that's I'm getting garnished at my job.
All right. Do you have any other basis for your objection to garnishment?
I just can't afford to pay them.
All right. Mr. Naslin, your response.
I'm sympathetic to her situation, Your Honor, but that's not a legal basis to object to a garnishment. She may want to talk to a bankruptcy lawyer or take some other action, but at this point, the garnishment is valid.
Yeah. Ma'am, financial hardship is something we all understand as human beings, but it's not a valid legal basis for an objection to garnishment. Having failed to state a valid objection to garnishment, the court must deny that objection. You have an absolute right, ma'am, to appeal by decision. That appeal must be perfected within 21 days today in Wayne County Circuit Court. Court will send out an order denying the objection to garnishment. Thank you for coming in. We are off the record.
Oh, can I ask you a question?
Ma'am?
Can I make an arrangement for the garnishment?
Ma'am, if you file a motion for installment payments, serve the other side, pay the motion fee, the court will consider it. But that's not before me today. The only thing before me today is the objection to garnishment that you filed. Thank you for coming in.
I would encourage her to contact the attorney on the paperwork in Livonia, Your Honor.
Counsel, you need to work on your equipment.
Yeah, I understand. I apologize sincerely.
Have a good day. Thank you for coming in.
Thank you.
Good morning, Your Honor.
Ms. Butler, good morning. What brings you here today?
Creditor's exam.
I think I had, are you looking for Richard Brooks?
I am.
What is your name, sir?
My name is Richard Brooks, Your Honor.
All right, raise your right, let me call the case first. This is file number 151194443. The file is entitled Community Alliance Credit Union versus Richard Brooks. Date and time for debtor's examination pursuant to subpoena. Mr. Brooks, could you raise your right hand, sir? You swear affirm testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, I'm going to put you guys into a chat room. Ms. Butler, you may conduct your examination. Let's get you guys into the chat room.
Thank you, Your Honor. When we're done, I'll probably need an adjourned date so Mr. Brooks can provide me with paperwork.
Well, let's see how it works out. Breakout rooms here. Mr. Brooks, number 3. Mr. Brooks, number 3. Okay, and let's see if he's there. Just hit join there. There you go.
Morning, Your Honor.
Mr. Truba, what brings you here today?
On the plaintiff on 846.
Okay. I don't have the other side as of yet. Have you received any pleadings from them as of yet?
No, we have not, Your Honor.
Okay. This is your motion to set aside. Let's give them a couple of minutes.
Okay, fair enough, Your Honor.
Thank you. Back in the waiting room. Ms. Butler?
Your Honor, I conducted my exam. He in fact doesn't have anything that I need because it doesn't exist for him. So I think we're done today.
All right. Thank you for coming in.
Thank you. Nice to see you.
Good to see you.
Bye-bye.
We are on the record calling file 2115846. The file is entitled Midland Credit Management versus Randy Mills. By a notice dated July 21st, 2022, This matter is set for hearing today, August 17th at 11 o'clock on plaintiff's motion to set aside dismissal, correct the register of action, and enter default judgment. It is now after 11:15. Could I have your appearance?
Good morning, Your Honor. Brian Truba appearing on behalf of the plaintiff, Midland Credit Management. My P number is 61752.
Mr. Truba, did you get any pleadings from the defendant, Randy Mills?
I have not, Your Honor.
Any response from Mr. Mills to your office?
No, Your Honor.
Sir, your motion.
Your Honor, this case arises out of the court's no progress dismissal entered on June 14th, 2022. By way of background, Your Honor, the defendant was served by this court's order for alternate service on October 5th, 2021. The default was entered on January 19th, 2022. And it looks like after that is where the issue came in, Your Honor. We received a judgment, and it looks like it was entered on the ROA. The default judgment was entered January 28th, 2022. About 2 weeks later, on February 17th, 2022, it looks like the court may have set that aside, but we didn't receive an order or any notice of that. At least I didn't see it when I reviewed the file. And then we received the no progress card, and ultimately the case was dismissed for no progress, and about a week after it was dismissed for no progress, on June 23rd, we filed the present motion. Simply put, Your Honor, it looks like the defendant was properly served in this case. We had a default, at least on our end, a default judgment had been issued and entered. And that's where we thought the case, at least the prejudgment side of the case ended. So for those reasons, Your Honor, it looks like that February 17th entry may be wrong. So we're asking that the dismissal be set aside and that the previously entered default judgment stand.
All right, the court's had an opportunity to review the file. And I note for the record that looking through the court file, there is the February 17th, 2022 judgment. And there's also a note, void should have been written on this. So apparently there was a clerical error at some point in time. In any event, the default having been in, the court is satisfied that the required jurisdiction over the defendant by means of alternate service. Default was timely entered. Your unopposed motion, sir, to set aside the dismissal, correct the register of action, and enter the default judgment will be granted. The proposed judgment that I have from you is in the amount of $1,157.18 plus costs totaling $1,239.18. Is that what you have?
That's what I have, Your Honor.
Okay, we'll enter that judgment for you today, sir.
Thank you, Your Honor.
Thank you for coming in. Appreciate it.
All right, Judge, have a good morning. Thank you.
Be safe. We're off the record. We are calling file number 21173367. Berman and Zuckerbrod Ophthalmology Associates PC versus Douglas Lewis. The court signed a subpoena on this matter on June 17th, 2022, setting this matter for creditor's examination today, August 17th at 11 o'clock. It's now 11:20, neither party having appeared. The subpoena issued on June 17th, 2022 is quashed. We are off the record.